When it comes to the definition of terms like healthy and organic, the meaning will often depend upon the doctor or scientist that you ask. But when it comes to food labeling in the United States, the ultimate meaning is often decided by lawyers in a court of law. Hello and welcome to Talks on Law at the Cutting Edge of Law. I'm your host, Joel Cohen. Today we're talking about food labeling, and our guest knows a great deal about this subject. Lauren Handel is a practitioner and an academic whose entire focus is food law. Lauren, welcome to Talks on Law.
Thank you for having me.
A lot of the law relating to labeling in the United States came out of tragedy, out of people eating things that turned out to be something quite different.
That's true. It's true of food regulation in general that a lot of the concern, at least initially, was on what's called economic adulteration, which means introducing cheaper ingredients or watering down food so that it's not what the consumer expects to get. It's not as high of a quality as the consumer expects to get. And so a lot of the labeling regulation has to do with addressing that problem. There are things called standards of identity in which food is defined by regulation. And so the particular terms in that standard have to be used to describe that food.
So when for example, in a restaurant, if they put a little extra water in your orange juice, you might never know, but if you're buying that orange juice at a supermarket, it should say very clearly whether they've added or not.
Yeah, orange juice is actually a defined product, and it's you might be surprised what's in orange juice actually under the regulation, but it is something that if consumers cared to find out exactly what it means to have a product labeled as orange juice, they could look it up in the regulation and find out.
So when it comes to labeling, it's both to ensure the quality of the product and to inform the customer about what they're buying.
That's true. And today, consumers, and part of the sort of food movement that's going on, is that consumers are much more interested not only in what's in the product, that's very important, probably always has been, but now people are paying more attention to the health consequences of what they eat, but also to how food is made. People are very interested in the production practices in agriculture and in the manufacturing of food. What types of ingredients are they? Organic ingredients? Is it made with sustainable practices? Those are all kinds of things that people are interested in and that the market is trying to address in their labeling and marketing.
Why don't we start with a label that most of us are used to seeing, organic. Now, organic, I'm thinking back to my biology days, just meant that it came from some living organism. What does organic mean now? And then we'll talk a little bit about the case law involved.
Organic actually is defined in the law, in the Organic Food Production Act and USDA regulations and standards set by the National Organic Standards Board. And so it's a very defined term by regulation. And it means that agricultural products are produced using a set of practices or actually not using a set of excluded or prohibited practices.
So what types of things are excluded? Are we talking about certain pesticides?
Synthetic chemicals, genetically engineered plants are excluded from organic agriculture.
So when I see organic, I should know certain pesticides were not used. It's not GMO. What else?
Well, the label itself will tell you more if you know the regulations about how organic the product is. So if it's a whole fruit or vegetable, it's not been processed in any way and it's labeled as organic, that means, or it should mean, as long as the purveyor is complying with the law, that it was certified by an accredited third-party entity, which is a private organization that gets accredited by the government to go out and certify that the practices comply with the organic standards. If it's a processed product, there are a variety of labels that get used on the front of the package, which is called the principal display panel. It's the part that consumers are most likely to see.
So they can't hide it in the back underneath the barcode?
Some things get put on the back in the ingredients list. Information about who certified, what the name of the certifier and their address will also usually be on the back of the package. But on the front of the package, if it says organic, then that means that the product is at least 95% made from organic ingredients.
So there's a little bit of leeway to deal with trace products that may not live up to the high standard of 100% organic?
Okay, well, the other 5% often is non-agricultural products. So ingredients, for example, if it was a baked good that you would need for a leavening agent, some other kinds of additives that are needed in food production. There's actually a list in the regulations of allowable or prohibited substances in processed organic foods.
100% organic. Is that exactly what it sounds like?
It is.
So that is the same, but without the 5%.
That's right. It means
buffer.
All organic, all ingredients or processing aids are certified organic.
Are there other types of labels related to organic?
There are. You might see a label that says made with organic and then the name of some ingredient or category of ingredients, or made with organic soy. Maybe that's a product that has other ingredients, but that means that it's at least 70% organic ingredients, and the rules allow you to specify a few of the organic ingredients if it's at least 70%. So made with organic, fill in the blank.
Maybe this is a good time to talk about something that's perhaps more fundamental, which is the labeling protections aren't just about prohibiting false statements. They're also about avoiding misleading statements.
That's true. The test is false or misleading. As a general principle, it is illegal to sell what's called misbranded food, which means that anything on the label is false or misleading, or that the manufacturer fails to disclose something material about the food that consumers would want to know.
Why don't we take a look at a couple of examples? Why don't you share with us a case that would involve factually accurate labeling that just was determined to be misleading?
So an example of a kind of case, or there have been a number of cases involving labeling using the term antioxidant. There are rules, FDA rules, about when you can use an antioxidant claim on a food product. And you can only use that term if the particular nutrient has what's recognized antioxidant activity. There are a lot of food products out there now where the science may not be fully developed enough for FDA to agree that a product has recognized antioxidant activity.
I'm thinking blueberries, acai berries.
Blueberries, FDA would agree. Things like vitamin C, beta carotene, those are things that FDA will agree recognize antioxidant activity. There are a lot of green tea products that have newer nutrients that we're hearing about now in the marketplace that people would not have ever heard of before, where the manufacturers want to claim that the product has antioxidant activity or contains antioxidants or is high in antioxidants. Those are claims that you actually can't make legally under FDA regulations. They may be true. I mean, it's possibly a question just for science to figure out, but they could very well be true. And yet there have been some lawsuits where the allegations were that those claims were false or misleading because they violate FDA rules.
So here it may be the case where, in an effort to protect consumers, the FDA may be lagging a little bit behind the science.